Welcome to the Probate Nation television show. We continue our discussion today about how to probate an estate of a loved one. In Virginia, probate is a process to transfer the title or ownership of probate assets to the beneficiaries of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. The Probate Nation program today introduces you to the Fauquier County Commissioner of Accounts, who oversees the probate of Fauquier County estates. The Commissioner has oversight of and must approve many of your decisions in the probate, from what you propose to pay and have already paid, to what you distribute to each beneficiary of the Fauquier County estate being probated. This program will identify steps to take and pitfalls to avoid so you receive the Commissioner's necessary approval to continue on your probate journey. Gary Pearson has served in the Virginia Commissioner of Accounts system in Fauquier County for 12 years, beginning with his initial appointment as Assistant Commissioner in 2004 and then as full Commissioner in 2011. In addition to serving as Fauquier County Commissioner of Accounts, he maintains a private law practice with the law firm of Pearson & Pearson PC, where he and his wife, Attorney Lois Pearson, have teamed for over 33 years to practice estate and trust law in the Fauquier County community, in which they have deep roots and a long-standing familiarity. Please welcome Gary Pearson, Commissioner of Accounts for Fauquier County. Gary, welcome.
Thank you for having me.
Well, my pleasure. I appreciate you stopping by to talk with us about Fauquier County probates. We talk many times about the probate process in Virginia being very unique, but there's a real history behind that. I'd like you to take a few moments, if you could, and to kind of tell us how we got to where we are today.
Well, it did begin in 1849, basically, as far back as we can trace, resulting in the codification in Section 64.2 of the Code today. It is unique in that it's the only state in the country who has a kind of a monitoring system. We don't have a probate court. We don't have unadministered supervision where you just can go your own way. We have kind of a monitoring system. And, the patron saint of Commissioner of Accounts is Brockenborough Lamb, who I think basically describes it best. Judge Lamb wrote Virginia Probate Practice in 1956 and says about the system that the probate court is the court of orphans and widows. The Commissioner of Accounts is the executive arm of the court that supports the shield of orphans and widows, and that's pretty heady stuff. I think that's a good description of the role of the Commissioner of Accounts. And I think the system among judges and lawyers has widespread support, but is occasionally questioned. The last time really in public it was questioned was the conference created by the Virginia Supreme Court called Commissions on Virginia Courts in the 21st Century to benefit all, to exclude none. And that committee recommended we keep the system, but there was a vocal dissent of prominent law professors and attorneys on that committee that recommended demolishing the Commissioner of Accounts system. We've even had a governor of Virginia in 1998 in his inaugural address recommending the disbanding of the Commissioner of Accounts system. I don't think I'm really worried about that. That is not going to happen because the General Assembly would have to do that, and that would be an arduous process. It is a long-standing system, over 225 years. Mm-hmm. And I think that's a remote possibility, but we have to remember that a generation ago, the General Assembly had 60% lawyers. Now we're down to about 20%. So it's important to educate the public what the role of the commissioner system is.
Well, and sort of leading into that, taking on from that discussion, tell us a little bit about the duties and responsibilities that you have as a Commissioner of Accounts.
Well, we have about a range of 375 to 400 accounts in Fauquier County. 2 attorneys do work on these accounts, and we have 2 full-time staff. And we do have some seasonal staff. May 1st is the big trust account deadline. We are deluged with accounts this month, and we have law school interns and college interns come in and help us. So we do have some seasonal staff, and this is a busy time of year for us.
What information and materials are offered to the personal representative as they come out of the Fauquier County Probate Office with their certificate of qualification and start to begin to work with your office? What information do they get, or do you suggest they review?
At probate, when they qualify, the first act they engage in with the clerk, they're given a thick packet that my office has propagated in cooperation with the clerk called Information for Fiduciaries. And then the clerk creates a file for me that I should get in about 10 days to 2 weeks. And at that time, we'll generate an initial letter which has the very specific deadlines when they have to file an inventory and account by month, by day, by year. We try to review the creation documents. If there's anything out of the ordinary, like a pour over to a trust, we want to see that trust. We'll ask for it. If we see some provisions in the will that might cause trouble later on, we'll ask about that. So we do try to tailor this initial letter to the particular state that we're dealing with.
I think that's very helpful. Now, there is this booklet that you referenced that will show on screen called Information for Fiduciary, which is the first page of a very long document that you help author that folks should take the time to read, because it does help people understand. But I think you really pointed out something very unique, though. I think that when you get that file, you do take the time to go through and, in effect, apply that lawyer's eye towards those documents that are going to be governing this particular administration, and really draw that out and get specific in writing about the actual dates that are for this particular state.
It's good to kind of bring that letter out when we get that phone call. I didn't know I had to do this. And we can say, well, are you at this address? It certainly didn't come back. And didn't we tell you about these deadlines? So I think the code doesn't require us to do initial letter, but I believe the fiduciaries appreciate it. Certainly they're professionals.
It's a very helpful thing you do there. Now, critically, after someone has qualified, though, what are some of the very first steps that they should take to really get themselves started on the right track?
Well, as I'm sure your prior guests have noted, you have 4 months from qualification. The clock starts running to file your inventory. And then you have to file an annual account from qualification to a year out from the date of qualification. You have 16 months to do that. Right, almost, I would say, the day you qualify, try and find that tax ID number and walk across the street or get in the car and go to your bank to open up a separate estate account. Don't try and commingle funds with the existing account the decedent has or your personal account. We had that happen too. Go ahead and open up that first estate account, because we want to see those checking account statements and accounts with checks in that account. And your marshaled assets, you're trying to value them as a date of death to put in your inventory in part 1 of the inventory. And those are the first steps, Richard, that you do, is open up the account and start pouring the funds in it that the decedent owned.
Very good. So, again, you mentioned one of your critically important roles is to oversee, audit, and approve the inventory and the accounting. So, discuss a little bit further about how you guys overview and approve those types of documents that are filed.
Well, at the inventory level, we'll check the affidavit and notice, be sure that the fiduciary is notified everyone on the list of heirs and everyone in the will, and we have to kind of take on its face what they say is in the inventory. We get past that process, and 16 months out, we'll get the account. We'll post it on a posting list that we put on our website and try and put at a bulletin board by the courthouse. That's an ancient process the code prescribes to notify the community that we are reviewing an estate. I mean, creditors might want to come forward, beneficiaries might want to come forward. So we get through that process, and then my auditor, when they file the account, will look at these various brokerage statements, these checking account statements, look at the receipts that where the fiduciaries paid bills, be sure they match up, they got a valid receipt, and look at the council checks to be sure the item's paid, and then the all-important distributions. You have to compare those distribution receipts to the creation document. Are they distributed like the testator said in his will? And that's not always the case. Sometimes there's some discrepancy. The beneficiaries who didn't get as much might agree to that. Sometimes they won't. So that's kind of the audit process we go through. A detailed process to see what comes into that estate and what is dispersed out of the estate and what's to the creditors and what is distributed to beneficiaries.
So what happens, there is a time period in which they have to get those things done. So what happens if they fail to file in a timely manner? How do you folks respond?
You know, that happens. We'll ask, actually in 50% of the estate accounts, we ask for more information in a letter and give the fiduciaries usually a 30-day period. When they're still dragging their feet, we try and give them one more letter, what we call a $25 letter. The fee agreement, the fee order in our jurisdiction allows us to assess a $25 late fee to be paid by the fiduciary personally, not out of the estate funds. You don't want to kind of trip over that. You want to go ahead and do these things in a timely fashion. We still have problems, and we can't work them out in the office. We do have to put you on a quarterly delinquent list with the court, with the judge, to see what's happening here, you know, what's going wrong. But usually we don't get to that level. We'll resolve these things in-house.
So based on your experience in office on all the oversight and auditing you've been doing, what are some of the tips you might share with us about how to file a good estate account?
Well, you know, I think it is true that you can't hire a lawyer or an accountant to do the day-to-day stuff that the fiduciary should do, such as, you know, writing checks, paying the bills, marshaling assets. But I'm just about ready to say that you do need professional advice when you fill out the inventory, when you fill out these court filings of an account. Almost, except in the simplest of instances, it doesn't hurt to hire an attorney and pay him out of estate funds to review the account that you're going to present to the Commission of Accounts. I mean, the Commission of Accounts cannot be your lawyer. How can we know, you know, the detail and the background of what has happened with his estate? I got a call actually last week from a fiduciary, and I really recommended it to him that he get a lawyer. And he told me, he said, well, you're my lawyer.
Oh, my goodness.
And I said, no, I can't be your lawyer. I'm more or less supervising this for the judge. I can't be your lawyer. He says, well, what is that $800 in probate tax I paid a few months ago? Sure, you're my lawyer. So we got that straight. But I think that I can't underemphasize enough that you need professionals in the process, only in the simplest of instances. I'm not saying that they've got to prepare the inventories and accounts in all cases, although some things are complicated, they should. But at least let them review it and make some suggestions about improving it.
Okay, I think that's a very good idea. And so I don't think you've covered, what are the most common reasons an account is not approved?
You know, it happens in 50% of the instances. We typically don't get checking account statements. You know, we don't know the payees because they won't give us the counsel checks. The account doesn't balance. Most fiduciaries want to do the right thing. 90% of fiduciaries don't want to pocket the money or, you know, short other beneficiaries or creditors. They want to do the right thing, but they make inadvertent errors where we can improve the account that's transparent to the public. These accounts are recorded, they're recorded in the clerk's office. And you do this because interested parties, like creditors and beneficiaries 5 and 6 years later, may want to come in and review this. So, these errors, if you can correct them at the stage before they're close out the estate, that's very helpful and makes the system flow better.
That's a good idea. Now let's move on to the beneficiaries. They are, of course, the ultimate recipients of whatever remains in the estate. So how about some tips or suggestions you have for how beneficiaries should interact with the fiduciary and how your office communicates with them or talks or gets involved with them?
We'll take calls from beneficiaries, but most of our correspondence is with the fiduciaries because they're under our jurisdiction. They've signed a bond, a qualification in the code since they've signed a bond makes them accountable to the Commission of Accounts. But we'll take questions and calls from beneficiaries. Most of the time what we'll say is have you talked to the fiduciary about this? Have you talked to the lawyer fiduciary about this? And the answer is no. The code does have a requirement that if they in writing request all documents of the estates and request an inventory in the accounting, and they send that letter to me, I will ensure that they get copies of the inventories and the accounts. And matter of fact, the fiduciary has to sign a certificate of mailing that they have been requested to send those documents out, and I'll check that against any letter I receive. But again, if you're really concerned about some sort of malfeasance being done, you really need the beneficiary really needs to have his own counsel.
Okay. Well, of course, the next thing that we get involved with, of course, is before we can get to distributing assets is figuring out, if the creditors are owed any money and then, of course, whether or not there's enough money to pay everybody. Okay. Right. So what's the process in your office to at least begin to figure out who the creditors are?
Well, a creditor, of course, has a way to file a claim with the Commission of Accounts. That's a $50 fee, and the code prescribes provisions to file claims, and that's on file with us. We won't approve an account until we know that claim's paid. And then there's the debts and demands procedure, where a fiduciary can request debts and demands hearing, publicized in the paper, where any creditors come forward, and they also have to send out notice to any known creditors that this hearing is taking place, usually a time certain in my office. And often if I see some sort of disagreement at that stage when the hearing takes place in my office, I'll continue it for a contested hearing later on. But fiduciaries, please take this to heart. You pay bills and you haven't got enough money in that estate to pay the bill, you're personally responsible, because we do have an insolvent estate situation where we have a Category 9 where you prorate what money's left. And if you've already paid money out of the estate in derogation of the exemptions before Category 9, you're personally responsible for that. So that's when you really need professional help if you think you have an insolvent estate.
Okay. Hearings. We didn't quite touch on this, but I wanted to come back to that. Do you get involved in doing a lot, other than the debts and demands and creditor-related hearings, do you get involved in a lot of hearings in your office to help the states move along?
Yeah, there's a code section 64.2-1209. Basically, the commissioner in estate situations can hear any issue that would come before the circuit court. And we do some 1209 hearings. Kind of try to construe some things in the will or work out disputes between the various beneficiaries and creditors. And 1209 procedure is different from the debts and demands in insolvent state situation.
Okay.
So we do have actually maybe about as many as one a month of those hearings.
Okay. I know you've mentioned that those can be quite a lot of people involved in those sometimes.
That's right. We it's to the point where I'm capable of taking about 20 people in my conference room. I think I had one as high as 40 people. But we found a facility on the 4th floor of the courthouse.
Well, got it done. That's a lot of people to keep track of. Well, let's talk about, this sounds, as you meant, it's all very complicated. It doesn't sound, and to a layperson sometimes may not be complicated, but the reality is it is quite complicated. And so I know you've mentioned a couple of times, but it's your feeling that fiduciaries really do need to get an attorney and a CPA involved?
It almost, except in very, very simple situations, I think it's worth the money. You don't want to have this account refused and you keep coming back and you go back and forth and it drags on for 6 months. Why not spend out of estate funds, some money to have a professional review it before you submit it to the commissioner? I think it's money well spent. And because, the commissioner of accounts, I try to give fiduciaries one meeting, face to face if they want. And of course we'll answer questions on the phone. But we cannot be the lawyer for the fiduciary. As much as that man who paid that probate tax wanted me to be a lawyer, I can't do that. I don't have the background. It's really a conflict for me to do the estate for that fiduciary. And that's what some of them want you to do is, prepare it for them. And please, fiduciaries, think that through. There's usually some money just to review it in the estate.
And we certainly have advocated that throughout our programs over the last year or so, that people should take the time to talk with a lawyer. Just an hour or two a time can save you a lot of headaches down the road. They really can. Well, we've covered a lot of territory. How about some of your final thoughts about things you'd like to share with our viewers about the Fauquier County Commissioner of Accounts Office?
I think it's the Commissioner of Accounts system has got a lot of support in the Commonwealth. It's an old, ancient system. It is unique in this country. It's a monitoring system, but it's not a probate court system where they just take your money and parcel it out. You do have some states highly supervised in the probate aspect. But it's not so, and we have some states like Tennessee who have completely unsupervised probate situation. I mentioned the committee created by the Supreme Court and the dissent, and just to go ahead and do away with the system. Let fiduciaries and beneficiaries administer their own estates without any court input. But I believe the system we have is highly efficient. This user fee system is very streamlined, easy to do. In thinking and preparing for the presentation today, I thought, what is our mission statement in the Commission of Accounts system? I saw a mission statement come in the door today in the studio, very, very lengthy. I was thinking maybe could we boil it down to 3 words, like Google Corporation has a mission statement, don't do evil. But again, I go back to Judge Lamb and Virginia probate practice, and Judge Lamb described the system as a system that comes under attack every once in a while. People say it should be revamped, overhauled, restated. Revolution, go ahead and do away with it. And he describes those who want to do away with the system as shiny, bright pennies, kind of like those law professors and prominent attorneys on the committee in 2006. And he closes with this. He says, changes will come, changes should come, but let them come deliberately and slowly, step after thoughtful step. Each tried out and tested before the next is taken. Richard, I walk past this every day, and I walked past a mission statement coming to the studio this morning, and that's kind of like Google's statement, don't do evil. That's what we're trying to do in the commission system, don't do evil.
And you're doing a great job. You're doing a great job. And Gary, I want to thank you for taking the time to visit with us today, for sharing your valuable insights and for your continued public service to the Fauquier County Circuit Court and to the citizens of Fauquier County. Thank you again for all that you do.
Thank you, Richard.
You're very welcome. I want to remind our viewers that the information for fiduciary booklet provided by the clerk of Fauquier County Circuit Court, as well as the information on the Fauquier County Commission of Accounts website at www.pearsonlaw.com, provides practical guidance to Fauquier County fiduciaries probating estate. We encourage anyone who wants more information to take a look at that helpful information booklet or check out the Fauquier Probate Office website and the Fauquier Commission of Accounts website. Some of this information or links to this information will also be set forth on the Probate Nation website. You know, without a doubt, probate can be complicated and confusing. You know, Commissioner Gary Pearson and the entire staff at the Fauquier County Commission of Accounts office do a wonderful job of explaining, teaching, guiding folks who are responsible for probating Fauquier County estates, you know, beginning with what needs to be done, when, and by who. You know, from inventory filings to accountings, debt hearings, and distributions to beneficiaries. You know, each and every topic, you know, and much more is in fact laid out in very simple, plain language in that information for fiduciary booklet. You know, but shortly after you have been qualified at the Fauquier Probate Office, you know, Gary does something very special in each estate by reviewing all the qualification filings, and in particular what was admitted to probate, whether it's going to be a will or happen to be by intestate succession. And then he prepares a detailed letter about the specific estate that needs to be probate, what needs to be filed when, and sends it out to the qualified fiduciary. If he sees issues in the estate, he's going to also identify those as well. This is a great way to get you started on the right foot at the outset of your estate administration, and it's a very, very key step in the process. If you still have questions, though, send or fax them a letter, or if you have not already done so, call and make an appointment. And you can certainly arrange to have a face-to-face meeting with Mr. Pearson in their offices at the Warrenton Commission, at the Commissioner of Accounts office across from the Fauquier County Courthouse. You know, they perform a great service for the Fauquier County Circuit Court and the Fauquier County community, and we're thankful for their commitment to do so. This brings us to the conclusion of our show on the Fauquier County Commission of Accounts. You're now qualified in the Fauquier County Probate Office, and you now understand the role of the Commissioner of Accounts office in your Fauquier County probate journey, including what you need to file with them and how they can help you along the way. Soon you will get your letter from the Commissioner of Accounts with his initial guidance, including a strong recommendation that you also consult an attorney and an accountant early in the administration process. Future shows will delve into the details of estate administration, but in the meantime, take a moment to enjoy the view as your probate train picks up speed and continues on its journey through the Fauquier County countryside. On behalf of myself and the Probate Nation, thank you for visiting with us.